this is an emotional case for a lot of people. Almost all cases involving a charge of first-degree murder are. The judges in this district handle a number of first-degree murder cases all the time. This case is governed by the same rules of law, evidence, and procedure that apply to all of those cases. In addition, please remember, comments, displays, or outbursts are strictly prohibited. If at any time during the proceedings you feel that at the onset of an emotional reaction that may violate the court's order, please quietly and discreetly exit the courtroom. There is no in and out. Once you leave, for whatever reason, you will not be permitted back in. With that,
thank you, Your Honor. We earlier today filed the formal charges to the court system, and I'm handing you a paper copy to the defense team now.
Yeah, when did you do that?
It was earlier this morning, Judge.
I don't think it's made it out of the clerk's office.
Okay, I can advise the court of what those charges are if you'd like.
Yes, because it hasn't made it out of the clerk's office yet. So
Okay.
when you file it downstairs electronically, it takes roughly about a day or so for it to get to us. Looked at it, and it's, it just got lost.
The magic of the digital age.
Yeah. As I looked at like it wasn't there yet. So what I have is 4 counts, is that correct?
That's exactly right, Judge.
All right. Ms. Stroll.
We have received that, Your Honor, and we have advised Ms. Stauch. Sorry.
Okay.
Of the 4-count complaint and information with your advisement.
Okay. All right. And there's a couple. I want to proceed this case because of count 1, first-degree murder. This would proceed. There's some water over there.
I have some water, I'm sorry.
This case would normally proceed to a proof evident presumption grade hearing. Is that what you want to set at this point in time?
Judge, we're actually asking for a review hearing to be set in 21 to 30 days. Mr. Allen has let us know that it's unlikely that we'll receive any discovery in this case until 21 days from now. And so as a result, we are not in a position where we can set the case for preliminary hearing and proof evident presumption grade hearing. We also attest to the arrest warrant affidavit.
I'm going to deal with that in a moment.
Right, and so we have no idea, we are not in a position where we can tell the judge.
And I know that. I know that
Okay.
you don't have the PC affidavit. What's going on with the discovery?
Judge, this case spanned the investigative portion of this case. It still actually is ongoing to one degree, but it spanned roughly 5 weeks before the arrest affidavit was given to a judge.
I have seen the PC affidavit.
Yes.
Okay.
And so the discovery in this case is very voluminous. We're over 1,000 pages already, based on what I've been told from the Sheriff's Office and the FBI. There is tons of video evidence, electronic data from cell phones and that kind of thing. So we are working. We have advised them of what that 21 days looks like as far as when we need to turn over discovery to defense. I just know that because of just the sheer volume of this case, I don't even have reports yet.
Okay, and before we get too far down that road, there's a couple of things that I need to deal with. First of all, Ms.
I'm good, Judge. I can answer your question.
Ms. Strobel, I know that there are search warrants. I've had cases in the past where sometimes they want the search warrant before the proof evident presumption grade, sometimes they don't. What are you wanting to do?
We want copies of the warrants. Is that the court's question?
Yes,
Yes, we do.
before the proof evident presumption
Yes,
grade.
Judge.
As you know, or actually as counsel may not know because a lot of them don't, those search warrants are not filed for this proceeding. How many warrants we talking about?
Judge, the last number that I heard was over 107 search warrants in this case. Yes,
107.
107.
Okay.
I think that number is bigger than that number, though, just based on
Are they all, were they all issued locally by a judge locally?
No, there were some search warrants issued in South Carolina as well.
Okay, so take a look at those.
And all of those were done with motions to seal as well.
Okay.
except for South Carolina, that does not have the sealing process that we have locally.
Okay. All right. This would be my thought. First of all, I am going to order that the PC affidavit itself, or a copy of the PC affidavit, be released in discovery to defense immediately. That, I think, would give them some idea about what the investigation is, what it is that they think they may need to have at some point in the future. You have it?
No, my request, Judge, is that the court order it be emailed to us rather than it go through the discovery process. It will just take longer. If you could email it to us, we would get it directly.
Yeah, that's fine with us too, Judge. I don't know if it's actually in ISIS.
It is, but it's sealed.
Okay.
I'm not going to unseal it just yet. That's a different issue that I'll deal with here in a few minutes.
Okay. I didn't know if you could just leave it as protected so that only defense can get it. I didn't know if that was an option or not. We can certainly email it though.
Probably. Let's email logistic way to get it to them. Because that way at least they'll know sort of where the electronic issues are, or where the search warrant issues are. So email that to them by Monday.
I'll do it when I get back to the office.
Perfect. So they'll have that. All right. And then my thought was that we would set this for a sort of status conference on April 15th, 4 p.m.
Is there any way we could do the week before that? I'm supposed to start a homicide trial in Division 8 on April 13th. Or I could do, I know we're taking the docket day off for that trial for April 14th, if you could do that at 4 o'clock.
Actually, before I get in trouble with my staff, which is the best staff in the book, I'll let them handle the dates because I will not get it right. But my thought is that we have a status conference back to warrants. I'll give the parties more instruction here in just a moment.
One of the 14th, which is a Tuesday.
If that works for the court.
We can do April 14th in the afternoon, 3 o'clock. And we do have trials.
I think it'll be all right.
If we did it at this time?
We can do it at 3.
Okay, so April 14th at 3 p.m.
Judge, just for the record, that works with us and with the victim's family.
Okay, so April 14th, 3 p.m. Okay. We're going to do a couple of things between now and then. First thing that Mr. Allen's going to do is release the PC affidavit by email to Ms. Strobel. Second thing that Mr. Allen is going to have for me later than April 14th is the number on the warrants and where they are. The ones that are here are going to be easier to access than the ones. And I want to know what kind of warrants we're talking about in South Carolina, whether it's, I have no idea. It could be anything from wiretap to the search of a car or phone, whatever.
Those were search warrants, Judge.
Well, I know that, but a search of what? So I just need to know that, so I have some idea about what that plan is going to look like. So we'll deal with that on April 14th. And then we should have some idea about how long it's gonna take to get these warrants released. And, my read on, as I said, I've read the PC affidavit. My read on some is that there's gonna need to be some significant redactions as a result of Chief Justice Directive 0501, because there's dates of birth,
Yes.
all kinds of personal information like that. Is that fair?
That's absolutely fair.
Okay. When we come back, if you can give me an idea about how many pages we're talking about, because it's gonna be our clerk's office that hits.
So, I think we're talking about, there's two issues with the search warrants. When we do our discovery, there will be a section in our discovery that goes to defense that will have every search warrant in it. So they'll have access to that as soon as the discovery book is put together and released to them.
Okay.
And then I'm not sure if the court is asking on those search warrants, the affidavit.
Not yet.
Okay.
I don't know, there hasn't been a request for that, I don't know if there will be, and I don't know whether it would be entertained. One of the reasons I asked that is because, at the end, I'm going to get to that page.
Okay.
But I'll need to have that. But it sounds like you can just release the warrants to defense through regular discovery.
That's how it typically will go, and it will be done on this case as well. It will typically be a separate section in the discovery packet that goes to them.
Okay. All right. Okay. And both sides have gotten a copy of the method of filing pleadings that I sent out. I think it was order 04,
Yes, Judge, the people acknowledge that.
order 02, and Ms. Strobel.
Yes, Judge.
Ms. Chalmers is familiar with that because it's the same process that I used in Galway.
I reviewed it.
Let's see, and, there is a, motion by from, Mr. Zansberg on behalf of the Associated Press to release the probable cause affidavit. Ms. Strobel, have you?
A couple hours ago.
Oh, okay. Well, that takes care of that because I was going to order a response to be made, so I will get an order out that the response is there, and I will give Mr. Zansberg an opportunity to reply, and then I will deal with that. One of the other things that I wanted to confirm, because it's represented in the motion, that the prosecution does not object to the unsealing of the probable accurate.
That is accurate, Judge. The status of the motions to seal were based on the investigation during the formulation of that investigation. That issue for us has expired, and we don't have that same concern that we had before. So that's why we have no objection.
Okay. Okay, so we have the date. Okay. I know that there are some members of the press that are here. I hope you'll listen to this part and follow it. We'll see. The rules in the state of Colorado govern what media access is available during criminal trials. Rule 3A of the Public Access to Information Records Rules, which was promulgated by the Colorado Supreme Court, says there shall be no expanded media coverage of pretrial hearings in criminal cases except advisements and arraignments. That's where we are. So the next step here, you heard that we had set a date for April 14th. That is not subject to expanded media coverage by rule in this state. The next to that is set up for a proof evident presumption grade hearing. There will be evidence presented at that hearing, but that hearing we cannot allow expanded media coverage by rule in that hearing either. It would be helpful to me and my staff if you didn't file motions requesting expanded media coverage, since they would be summarily denied, but we have to read them but it would be helpful if you didn't do that, because by rule, it cannot be granted. I think that resolves all outstanding matters that I had. Mr. Allen, is there anything else that you wanted the court to address?
Judge, I guess just formally for the record, it sounds like defense is waiving the requirement to have that proof evident presumption great within the time requirements.
Good point. Ms. Strobel?
Judge, we would just like to reserve our right to prove evident presumption grade at this time.
No, and
And
I
we'll waive
understand.
the 35 days.
Okay, right, okay. As I understand it, I think I didn't interpret your request for a delay as a waiver of the hearing. I get it. You gotta see what the PC affidavit and perhaps the search warrants had to say before you can make a determination about that and be prepared for a proof evident presumption grade hearing. But you're waiving the time requirements related to that, is that
Yes.
correct? Is there anything else that we need to address from the prosecution standpoint, Mr. Allen?
Both defense and people filed some motions. Are we going to take those up at the next court setting?
Yeah, we'll take them up at the next court setting, unless there's something immediate that you want me to answer. I mean, it would be the fairly standard stock motions. The defense, as far as I know, has always filed in first-degree murder cases. There wasn't anything specifically directed to a specific fact in this case. It was all preserved notes, preserved evidence, those kinds of things. So if there's something immediate that you want me to address?
Nothing immediate, Judge. I just was making sure that that's what the game plan was.
No, we'll deal with it. And I saw that you had filed a response. I may issue the written order on it when we get there. Ms. Strobel, from the defense standpoint, anything that you want me to address?
Judge, if the court's going to issue written orders, that's fine. I think everybody's had a chance to bring up their issues. My only concern would be preservation of evidence and testing of evidence that issues orders. No consumptive testing.
Well, I thought I saw in one of the motions or the responses that you filed that the prosecution's office agreed that there would be no destructive or consumptive testing of evidence until order is entered by the court.
That's exactly right, Judge.
Okay, that's typically the rule, so.
Yeah, there is obviously ongoing testing. We will stop if there's anything that's going to be consumptive or destructive and seek the court's approval.
And I dealt with those before,
Yes.
so I figured that would come up if that were an issue. Anything else from either side, Mr. Allen?
No, Judge, thank you.
Ms. Strobel?
Judge, I just wanted to bring up.
Hold on, Ms. Strobel.
No, Judge, Ms. Chalmers is going to
Ms. Chalmers.
wrap it up.
Thank you, Judge. I just wanted to bring it to the court's attention. I mentioned this to Ms. The court wants us to write a written motion on this. This has been an issue in other cases, and I think written orders have been issued. It's our understanding this case was originally assigned to Division 5, and then it got rerouted to Division 15, and we've reviewed two chief justice orders, and it sounds like usually there's a written order by the chief judge about why it was rerouted, and we haven't received that. And so I don't know if the court can.
I'm not aware of that.
Okay.
But what I can tell you is, I think what happened was, as you know, all judges in 4th Judicial District are on a homicide rotation.
Right.
And it's based purely by number of division. So first homicide goes to Division 1, second homicide goes to Division 2, on up through, I think we're 24 now. But that's how it's assigned. There is also I'm not as good as the clerks at explaining this, but there's also a matrix for assignment of cases to divisions. And if I remember right, it's based on the last two numbers that are in the case number. So what happened in this case was that based on the case number only, it was sent to Division 5. Once they realized that it was a first-degree murder and it should go to the homicide rotation,
Your Honor.
next up.
Okay. Thank you for explaining that. That makes sense. We were just confused, and I know that it's an issue that people have raised in other court cases in this jurisdiction, and we didn't have any idea why that happened, but it makes sense.
All I can tell you is I was sitting there and one day I got assigned the case. It
Okay.
showed up.
Thank you, Judge.
That's what it is. And it's about like the other homicides that I've had in division, because something gets filed and then all of a sudden it's turned into a first-degree murder case and it gets moved to a different division.
Right.
That's exactly what happened.
Okay. That makes sense. Thank you very much, Judge.
All right.